Most of our clients have never been involved with a lawsuit before, so we thought it'd be a good idea to kind of provide a little initial information about what the litigation process entails and specifically what to expect before you call our office. The first thing that will happen when you call our office is you'll talk to our intake coordinator, who will basically go through a script with you, kind of a who, what, when, where, and why of your case and what's going on, kind of why you believe you're harmed, who you work for, etc. She might also ask you to provide some documents such as pay stubs, employment agreements, or other documents related to your case. After we get all the information through our intake coordinator, your case will then be reviewed by one of our attorneys here at the firm. Once we review the case, we'll either decide that it's something that we think you might have a claim, a valid California labor law claim, or not. If we think you have a claim, basically we'll schedule immediately. We try to get people in within a week or so, a meeting with one of our attorneys here at our office. In that meeting, basically we kind of go through a little bit more detail of the same factual issues related to your claim, what happened, who are the players involved, and what laws might have been violated, what rights you might have to pursue a claim. Some of those meetings result in cases that we can go ahead and take on and lawsuits to file. Some of them do not, but we'll always give you a straight answer of whether or not we think it's something that makes sense for you to pursue. If we do think it is a case, basically the next step would be for us to give you a retainer agreement. The agreement is basically the contract between you and ourselves, us agreeing to represent you and you agreeing to hire us to represent you in your claim. It's got all the financial terms, kind of, as well as who we're suing, what we're suing for, and what to expect in the representation. We would give that to you, give you some time to take a look at it, have it reviewed by someone else, another attorney if you want, and sign up. Basically, you can feel free to ask us any questions you have about it, but once we get that back signed from you, then we begin working on your case as your attorneys. Basically, we would then draft a pleading, usually a lawsuit in most cases, to pursue whatever legal remedies we're working on for you against your former employer. Once that lawsuit's filed, it takes a little bit of time for the courts to process the documents and get everything back to us. Once we get the lawsuit back, we generally provide it to our process server, who goes ahead and serves it on the former employer or current employer sometimes. And we basically, as soon as that's served, we're up and running in litigation. The next step in litigation is generally discovery. Discovery entails the asking of questions. We'll ask written questions to your former employer. We'll ask for documents, and they'll do the same of us. We'll have to work with you in providing documents and answers to written questions. In many cases, your deposition will be taken as well. Basically, a deposition is having another attorney, the defendant's attorney, asking you questions related to your case. Now, we as your attorneys would be with you in that whole time and be able to advise you whether or not to answer the question or objecting when the question is improper. That goes on for usually a period of 6 months, 7 months sometimes, and kind of allows each side to gather information about the case. After that has basically, all the questions and answers have taken place, generally speaking, in California, the parties will decide to mediate. This can be done through a private mediator, someone that is paid for by the parties, or other times the courts will actually provide a mediation process. And mediation is basically when the parties get together and try to work on resolving the claim. There's a negotiation. Usually plaintiff starts with a number, defendant counters that number, and they try to come up with a number that makes sense for both parties to settle the case. If this mediation is successful, then the case will be dismissed and usually a settlement will be paid out. If this isn't successful, then basically the next step would be trial. We would work with you and prepare you as a witness, prepare other witnesses, and put on your case in front of either a jury of your peers or a judge in some cases as well. And that's basically the main steps that will take place in a litigation of an employment case in California.